Hi, everyone. We'll get started in a minute. Hi, everybody. Just have a couple more people joining us here. Okay. Let's see, did I record? Yes, I recorded. All right. We'll go ahead and get started because we have a lot of content. Hi, everyone. Great to see you all. People are still joining. This is part 3 of a 4-part series designed to get us ready to do some affirmative asylum clinics starting in, well, really like January sometime. And so tonight's talk is about just the really practical components of an asylum case, like how you actually do the work. But I know we skipped part 2, which was the ethical considerations of limited representation and just kind of common ethical issues in immigration practice. My girls were really sick. They had RSV, so I had to take one of them to the hospital. So that's why we sadly had to cancel that one. So Danny and I are going to record that. So Danny's my husband. He's an ethics lawyer and he has a background in immigration. So we're going to record that and send it out as soon as we have time to record it. It just depends on how much mess Christy Nome sends our way and when we can get it done. So we'll get that out to you. If you're not on the listserv, like if you haven't sent me, if you haven't received an email from me directly, you're not on our listserv. So send me an email so I can get you on our list. I'm going to put my email in the chat now. Okay. So in terms of the training tonight, I structured this so that the PowerPoint serves as like a handout for you so that if you're working on cases, you can pull up the PowerPoint and use it as like a checklist so you remember what you're doing because asylum cases are super complicated, as we all know. So the way we're going to do this is I will explain kind of like each major part of an asylum case, and then I'll pause to one, see if you have comments or questions, and two, I think everyone from our legal team is here. So if any of you all have comments to add, please chime in. Okay, so I made a PowerPoint. I'm gonna share my screen. Let's see. I can remember that. Okay. Okay. There we go. So this is part 1 because we're doing part 2 next week, and part 2 is on brief writing, like the legal argument for asylum cases. And this is basically everything else, part 1. Okay, so as I mentioned, the limited representation clinics that we're going to do starting in January, that's a partnership with Kayak. It's really nice to pair up with another organization, and we got funding to do this for 2 years. So I know not everyone on this call is going to be a part of that clinical program necessarily, but what we'll talk about is generally applicable to affirmative asylum representation. And so our goal, one of our big goals at Arise, is to expand capacity in the field because so many people need help and so few people know how to do this work. So, thinking about limited representation, like what does that mean? So, you might have heard like of pro se clinics or limited representation clinics where you help people fill out their form, like the application for asylum. This is quite a bit more in depth than that. So what we will be doing is helping people, yes, fill out their application for asylum, but also compile all the other things you compile and you turn into the government to create a strong claim for asylum. So we're going to be doing everything up until the point of submission, and then we submit the application, and then the client is referred to someone else for continued representation. So when we get into the clinics, we'll go into more of the nuances of that, because that itself is a little bit complicated, like handing a case off to someone else. But the idea here is we're trying to create the documentary case so the client can file it with the government. So one just distinction to be aware of is that at Arise, we generally only do affirmative asylum cases. as opposed to defensive. So affirmative asylum cases are what people file when they're not in removal proceedings. Um, and then folks who are in removal proceedings, who are actually being prosecuted by the government intends to deport them. Those folks would file a defensive asylum application with an immigration judge. So the legal requirements for asylum are the same in either context, affirmative or defensive, but there's a lot of like procedural barriers that exist in a defensive context that we don't have to deal with. Okay. Okay, so a big goal of mine in this presentation is to help you see that there are a lot of ways you can really help with minimal training. If you are a person who's attentive to detail and good with other human beings, there's a lot that you can do to help an asylum seeker submit their application, so long as you're appropriately supervised. So I'm really trying to kind of distill down the big picture things you have to think about in order to help on an asylum case. So that's what we do at Arise. Like our legal team consists of 4 people, myself and 3 other advocates, and we oversee the work that's done by other folks, and it works very well. And so I'm saying this because we get a lot of questions about unauthorized practice of law, and we'll talk about that in the conversation we have with Danny. But the idea here is you can do a lot so long as you're appropriately supervised, then you're not practicing law on your own, which is illegal. Okay. So a big theme in asylum representation is being client-centered. So that's kind of a buzzword, I think, nowadays, but the reason why we do it, the main reason, is because it works. So being client-centered means a lot of different things. I think in general, the overall like definition of client-centered legal advocacy is that the client steers the ship, like they make the decisions, and we honor those decisions. So as long as your client isn't asking you to do something that's unethical or dishonest, et cetera, we really want to have them be in the driver's seat to the extent that that's possible. And this works really well with people who have been severely traumatized, as most of our clients have. When we respect the autonomy in another person, it generally makes the process easier because it is a really challenging process, as you'll kind of see as we discuss the nuts and bolts of these applications. So one of the things we're trying to do is minimize the harm, like the re-traumatization that the client has to go through as they relive all of these traumatic experiences that force them out of their countries, even as they're living in like chronic stress, being in this country now. So we're constantly thinking about that. And sometimes that means like we have a long list of questions we have for clients as we're preparing their case. Sometimes that means backing off of that long list and being satisfied with covering half the material we were intending to cover. So I lead with this because I think it's super important to remain committed to being client-centered, and it leads to very good outcomes. So I think that in my experience, having trained a lot of lawyers and advocates in asylum advocacy, I think the biggest mistake that new advocates make is that they exasperate their client. And it's very easy to do because the legal requirements are so intense and so hard, but it's a great way to make someone give up, to alienate them and hurt the rapport building process, and also to stress them out so much to the extent that they forget. Like, our memories are already fragile, as we learned from Jen Bulcock's discussion about trauma responsive advocacy. Our memories are already limited when we're recalling traumatic material. So if we make that worse because we're exasperating our client, then it just kind of makes the whole case fall apart. So we really just try to do the opposite by being aware of the amount of stress we're inflicting and just acknowledging and asking questions about the client's preferences. Okay, so that's being client-centered in a very broad, from a very broad perspective. Okay, so in terms of our process, and this is pretty similar, I would say, like from organization to organization, like a legal service provider, we generally have like very similar intake processes. So first, clients fill out an intake form on our website. And then for the cases that look strong, because we really only take strong cases, we schedule a Zoom meeting with them to do an interview. And then if it looks like a case that we can take, we explain the full process, set expectations, answer questions. We do a retainer, which is a formal agreement between the client and Arise, explaining the nature of the representation, what it consists of. We put any disclaimers in there, like any risks that we see. We want to put that in writing from the jump. And then we get to work on the case. So in this particular context, like the clinical context that I mentioned that we're going to do over the course of 2 years, this is limited representation, meaning we're doing the application, supporting documents, submitting it, and that's it. Then we're going to hand the case off. However, I'm going to mention kind of throughout this talk that clients tend to really focus on the interview because that's like the big stressful event, right? So they tend to ask a lot of questions about the interview, even if we're not representing them for that, because a lot of people are going to wait a very long time for an interview for asylum. But they still want to talk about it. So again, like harping on that whole client-centered idea, I think it's really important to try to answer those questions and try to deal with those stresses that the clients generally have, like those kind of questions before you get into the meat of their case, because a lot of times you can build a lot of rapport if you handle those issues from the jump. So that's an overview of the process. In terms of intake, like how do we select clients? And again, broadly applicable, even if you're working cases in another part of the country with another organization. We screen for 3 things because we're trying to take strong cases for a lot of reasons. Like we don't want to take weak cases that are likely to be denied because that's kind of a disservice to our clients. We don't want to put them at risk because if they're denied at the asylum office, then they'll likely be put in removal proceedings. And it's extremely expensive to defend yourself in removal proceedings because nonprofit providers are super limited in their capacity to do that kind of work. So we keep all that in mind, which is why we take strong cases. So the 3 things we're screening for: general eligibility, meaning do they satisfy the elements for asylum? And then the bars for asylum, those have become pretty expansive over the course of the last, I would say, like 6 to 8 years, because we don't want to submit an application for someone who has an overt bar to asylum. Sometimes those are gray areas and they're arguable issues, so we can argue that a bar does not apply, but we're always screening for them from the jump. And then this is kind of an important, sometimes counterintuitive aspect of screening, and that is like the workability. Can we work up this case? Do we have the right interpreter? Is the client receptive to the legal theory? So like, for example, we did an intake, I don't know, maybe like 2 months ago or so. And I thought it seemed like a really strong religious persecution case. The gentleman was from, I don't remember the country in Africa, but it was somewhere that was experiencing a lot of persecution of Christians. And this gentleman was a pastor and a Christian, but he could not identify that he was being targeted because of his religion. It actually sounded as though he was being targeted because of his religion, but he didn't agree with that assertion. So we ended up not taking the case because it just wasn't arguable if he didn't agree with that assessment, if he didn't agree with the protected ground and the nexus. So that's what workability is. We're screening for, can we make these arguments? Will the client interview well to satisfy the criteria for asylum when they're there and under incredible stress with the asylum officer? Okay, so once we get the case, we're really thinking about the legal requirements. So I mentioned to you that I'm hoping that this talk tonight leaves you with like the distilled, or I should say like the kind of a simple outline of what you're trying to do through an asylum case. So this is the complicated stuff. If you're going to narrow asylum protection down to like 3 requirements that you need, it's these 3 things. be in the US or at a port of entry, satisfy the legal definition of a refugee, and not be subject to a bar. But I'm just going to read this because this is the statute. This is the legal definition of a refugee, and I think it's really confusing. But we'll simplify it in a second. So, a refugee is any person who is outside any country of such person's nationality, or in the case of a person having no nationality, is outside any country in which such person last habitually resided and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So I'm reading that because almost any statute I ever read in immigration law is just as confusing as that one is. Like, it's poorly worded. You really have to kind of parse it out to understand it. But there's good news. Like, there is a way to break this down in a way that's understandable. So when you're reading your next regulation or statute and you feel confused, that's very normal. Most of this stuff is poorly worded. But these are the requirements that you're looking for. This is what you're trying to prove through an asylum case. So this slide here is the most important slide in this presentation. So if you're going to screenshot something or pay attention to anything, it's this one. Because when you're working up an asylum case, really, regardless of what task you're doing something related to one of these elements here. So we're going to go through the different requirements. Past persecution. So past persecution is a threshold issue, meaning does the harm rise to the level of persecution, or is it just harm? So these different elements vary a little bit depending on what circuit you're in, or what day of the week is and what the BIA is saying about these different elements. But there are some generalizations here that we can cling to so that we can at least interview our client to get the information we need from them to make the argument. So, like, for example, past persecution in the Fourth Circuit, which is what we're arguing here, for Pittsburgh area clients, because they interview down in Virginia, which is in the Fourth Circuit, mere harassment does not rise to the level of persecution, right? So I don't like to use that word in asylum cases because harassment doesn't qualify as past persecution. Or for arguing future-based fears, it doesn't qualify in that context either. But death threats are past persecution in the Fourth Circuit. That's a little bit surprising because they're just threats. It's not physical harm. So depending on where you are and the different case law that applies, persecution can change a bit. But what you're screening for is like the severity of the harm. And then in terms of well-founded fear of future persecution, it's the same concept. You're just trying to guess what would happen in the future. Meaning, like, how are other people with similar characterization or characteristics in that society that they fled, how are those people treated? Or say the persecutor is the government, like the person was detained, right? Was that government still in power? Then yeah, that would lend itself to having a well-founded fear in the future, right? Or maybe there was a regime change. Well, then maybe that cuts against the well-founded fear in the future, right? So that's persecution in terms of the two ways you're looking at it, in the past and the future. And then the protected ground is, you can think about that as like targeted persecution, right? So the government loves to argue that people are not eligible for asylum because they fled generalized violence. If you've been around us at Arise, you've heard me talk about that quite a few times. So generalized violence, meaning it's not targeted, right? Anyone's in harm's way. It's just a dangerous country. That's what our government likes to argue, to say that people are not eligible for asylum. The protected grounds are about the targeting, right? So some of these are more self-explanatory than others. So we have race, religion, nationality, political opinion, or membership in a particular social group. So religion's pretty clear, nationality's pretty clear, political opinion's a little more vague, but the two that I think are like the most confusing are particular social group and race. So race really varies like depending on the context, like the country. I've found that people from different parts of the world have a very different understanding of what race means. And so we argue it depending on like the country of origin for the client. So in some parts of the world, like skin color is a really big deal, and that's kind of how race is understood. In other parts of the world, like tribal affiliation, that's a really big deal. So that's how you argue it. It just depends on like the situation your client fled. Membership in a particular social group is a much more complex idea. So it's obviously a group, right, that's targeted in some way. Like there's some characteristics that they share. But the case law about particular social groups has evolved so much over the course of the last like 10 years that it's become like a very challenging thing to prove because there's a three-pronged test for particular social groups that you have to prove in order to present a cognizable particular social group to the government. So it's a little bit beyond the scope of this presentation, but one thing I will say is that there's a lot of good circuit case law across the country about particular social groups and which ones are real and which ones aren't. So if you're like us, if you're dealing with Fourth Circuit case law, there's some really great determinations about what are particular social groups. Like family-based particular social groups are very strong in the Fourth Circuit. That's one example. So it becomes much easier to argue that protected ground. So that's the targeting, the protected ground. And then nexus. So I highlighted nexus in red because I think for the most part, like practically when you're working up a case, nexus is the most important element. So nexus means the because, like why was the persecution inflicted or why is the person afraid of it in the future? So it's the nexus to the protected ground. And it's strange because you're assessing the persecutor's motivation for harming the person, right? Which is an odd concept because, like, I'll just use myself as an example. Like, I'm a registered independent, right? If someone's going to inflict persecution on me, they're not going to like come up to me and beat me and say, like, this is because you're an independent, right? That's just not how humans operate. But there's so much context given in our clients' cases about why they are targeted. It's just never explicit, so you always have to dig for it. So I had a great question about this recently by another lawyer. She was saying that in her experience screening asylum seekers, they tended to focus on the severity of the harm or just like how bad everything was, why they fled, rather than the reason why they were persecuted. And it's that nexus that really makes the asylum case. And it's nexus that adjudicators tend to fixate on. Because if you don't have nexus, the whole case falls apart. And often that's the easiest way for the government to deny the case. They just say, no nexus, I don't even have to analyze the other elements. So I think that this one in particular takes a lot of skill to screen for. And there's ways of doing that if your client doesn't necessarily know why they were targeted. There's ways of asking the questions without coaching them, like we never want to feed them information, but there's also opportunities for them to be educated too, so they understand the nature of the harm they fled, because there are times when clients don't. They just know that it was so bad they had to get out. But if they take some time to read and understand the country conditions, that can help facilitate the process. Like there have been situations where I've done an intake interview of someone who didn't understand Nexus, and I said, well, can you go read about your country? Like come back to me and see if you have more insight into the protected ground, right? Why you were targeted. And then we come back and we go from there. And we work up the case once they're able to understand it and articulate it. So Nexus, keep that like in the back of your mind while you're working up the case, because you really want to emphasize it as much as you can. And then, so for the last 2 points here, I think these are especially important under this administration because they're just obviously trying to deny cases. So your persecutor has to be either the government or a private actor that the government cannot control. So the BIA has issued a number of cases to try to heighten the standard under Trump 1.0 and now under 2.0 as well. So just something to bear in mind is that you're really trying to prove that the government cannot offer protection to your client. They just keep trying to make that hurdle higher and higher, but you can only deal with the facts you're given. So sometimes that means like having an expert witness explain the inadequacy of the government or the corruption of the government. Sometimes that means documenting that your client went to the police and the police did nothing. They just informed the perp, right? Because that happens a lot in countries of origin. But regardless, we have to address this element thoroughly because the government now is inclined to deny cases by saying that countries are safe to return home to. And so kind of related to that last point is that we want to argue that the threat is countrywide. So this is asylum law is a little strange in terms of like the frameworks that it creates, but if you prove past persecution on account of a protected ground, there is a presumption that you have a well-founded fear of future persecution. But the government can rebut that presumption if they can prove changed circumstances or that your client can internally relocate so they can move to a different part of the country. So again, under this administration, they're trying to rebut those presumptions, right? So that's why we really want to like lead in our argument by saying it's, countrywide, there's no protection anywhere else, it's a small country, whatever the facts are in your particular case. Okay, so those are the big points you're looking for when compiling the case in terms of the legal requirements. And then in terms of like the actual parts, like what you're filing with the government, it's the following. So the affidavit, the client's story, and then evidence can be super broad for asylum cases. It can be a psychological report. It can be an affidavit from mom. It can be, a picture of the persecutor holding their political flag to show their motivations, right? To satisfy nexus. It can be so many different things. Country conditions research, I think that's fairly self-explanatory. You're documenting the situation in the country. The brief or the legal argument, why they satisfy that strange definition of a refugee that I read a couple minutes ago. And that's a whole separate discussion we're going to have next week about how you write and how you understand legal arguments for asylum seekers. And then the actual application, which I think it's easy when you're kind of in a rush working these cases up. It's easy to think that, that's less of a task than the other portions I just mentioned. But the I-589 is a real bear. It's a long application, and it's really important that you cover those elements we went over in that application, because sometimes, depending on your officer, that's the only thing they'll read. So that's why, they might not read your affidavit that you file for your client, but you want the important parts of that affidavit to be embedded in the I-589, the application, in case they're lazy and they don't read anything else. And then there's the interview prep, which we're not doing with this particular project with the clinics, but I put it in here because clients are usually almost always going to ask questions about it, so we want to be responsive to those questions and help them feel prepared and like they can do well. Okay. So what I'll do is I'll go through the affidavit and then I'll pause for comments, questions, thoughts. Okay, so the affidavit, your client's story. I think if you're going to do this for the first time, go through that most important slide that I highlighted with the elements and use that as your guide. Or if maybe you've been doing this for a while and you're just sitting down with a client and it's stressful and you just need a guide, just use that as your outline, and that will give you a really good foundation for working up the asylum case. In terms of how does this work? How does the client actually produce their affidavit? There's so many ways for you to do that. If it's a client who seems more independent, is able to read and write, you might want to ask them to write up their own affidavit. Even if they're super educated, you almost always have to give them an outline because clients usually can't guess exactly what they need to write about. So that's kind of one end of the spectrum. The other end of the spectrum is meeting with a client and typing out what they tell you. that's usually what we do. That tends to work very well. It's a great way to build rapport with your client, and it's nice to not leave them guessing too. So you're kind of steering the process so they're not sitting down wondering with a pen and paper like what they're supposed to write, particularly since it's such awful material that we're asking them to recall. Um, so again, like the way I structured this PowerPoint is it's a checklist for you. If you're in a hurry and you're sitting down with a client, you can glance at this and hopefully it'll be enough guidance for you to get going. But just a couple points to think about, points that help me as I do this work. So we have a lot of material about trauma responsive advocacy, super helpful. Um, One, for understanding the way the brain functions after trauma occurs, but also for helping us feel competent, because it can be intimidating to interview someone who's from a completely different part of the world. You're using an interpreter. Maybe you're new to legal advocacy. I mean, you name it. There's a lot of barriers and a lot of opportunities to feel, kind of afraid of stepping in and doing such important work. Well, one of the things that is very helpful for me that a number of different counselors have taught us about is this idea of the arc. Because usually when you sit down with a client, you're going to get to traumatic material like during that first meeting, whether that's an intake or when you sit down to do the affidavit. So it really helps to ease into it. That's the bottom of the arc. However you're comfortable doing that. Maybe you want to talk about yourself. That's how you feel comfortable. Maybe you want to ask them questions about them. Whatever your style is, I think so many people can do this so many different ways. And then you just progress toward the traumatic material and give them a heads up about it and ask permission if you can ask these questions about this particular subject. And then you come down off the heavy material, ending with material that's as light as possible. Again, however that makes you feel comfortable and whatever you think would make them feel comfortable. Same idea. And I think when you're ending a conversation that's been noticeably hard for the person, like one of my favorite things to do is to ask them what they can do to help. Like what helps them? What can they do this weekend, right after they get off the call? What do they want to do with their kids? Like kind of that grounding, like what are they physically going to do that gets them out of that horrible headspace we were just in and into like next steps and taking care of themselves. So I think, right now when this is just a stressful time for all of us to be doing this, relying on those tools that we have been given by mental health professionals is super important. Like obviously it helps us minimize the damage and be better at this work, but I think it also helps us like as advocates understand that we can rest knowing that we did everything we could with the tools we were given to inflict the least amount of damage in a very stressful situation. So if you haven't seen Jen Bulcock's talk that she did a couple weeks ago, I'd highly recommend it. I thought it was really good. So in terms of the information you're gathering, it's generally the who, what, where, when, why. And I would say generally, it's pretty rare for a client to answer all of those questions. They either can't remember or they just don't know. Or there's some sort of impediment, like there's just some sort of barrier, they can't articulate it, whatever. And that's okay. I think that one thing that's surprising to newer advocates is that you don't have to have the level of detail that you might think you need to have. So even though these cases are scrutinized, we have received approvals for cases that have 2-page long affidavits that are not detailed at all because the clients just can't remember and it's been such an awful, several years for them, and that's sufficient. So you just kind of see what you can get. I think one benefit of the horrible situation we're in right now, where there's like condensed timeframes for everything, is that you want your filing to be as concise as possible, and that includes the affidavit. So when you can make it shorter, it's often a good idea to make it shorter. So it's nice that the client doesn't have to relive every detail. In terms of like common issues that we see with clients, asylum seekers tend to be super brave. They fled for a reason and they also had the strength to leave what was familiar. So there are actually some issues that come with that. Like a lot of times our clients will not articulate that they're afraid. uh, which is problematic because to qualify for asylum, you have to have objective and subjective fear. So objective means like a reasonable person would be afraid in the same situation. Subjective means like they're actually afraid. So that subjective fear is what you're looking for. So I've had clients where like I ask them if they're afraid and they're like, no, if I have to go back, I'll go back. And so I asked them very directly, like, well, but are you afraid of being killed? So sometimes you have to ask very direct questions. And I often apologize for asking like such crass questions, but you want them to be prepared to articulate the things they need to talk about. So that's kind of, I think, one of the common themes that we see is that people are brave, and so it's hard to get at these particular issues. I think also we see a lot of denial. Um, So, kind of related to that idea, like not wanting to face fear and bravery, a lot of people won't want to consider like the horrific things that could happen to loved ones, or even what could happen to them, right? So they kind of deny it. So rather than talking about how there's a real possibility that they'll be harmed if they go back, they might minimize it. So that's again, I think, a good opportunity to be really direct and just explain it to them, like explain what you're trying to argue to the government and how you think they're really brave or however you feel comfortable saying it so that you can really get to the bottom, like the truth of the risk and help them articulate that in a way that's honest for them. So like an example that's coming to mind is Kim, I hope you don't mind me sharing this. So Kim worked a case for a gentleman I think it was like over a year, about a year and a half ago. And he was super stoic, super stoic. And so as Kim was helping him, I think, write his affidavit, it was a family-based case. So I mentioned like those are very strong legally in the Fourth Circuit, but he had a hard time talking about his family. And it was also kind of complicated because there were some extended family members that were targeting like his immediate family. So he was sort of like undermining the risk, minimizing it. And so Kim had to ask him directly, like, do you think someone would harm you? Like, do you think someone would try to take your life if you go back? And he was like, oh, I don't even want to think about that. But like, we have to get clients to talk about those things or they're going to lose, like, they're going to be denied. So good job asking hard questions, Kim. I know it's like very uncomfortable and we all feel terrible usually after asking those questions, but I think we do a disservice to our clients if we don't. So a lot of this is probably commonsensical, but I think it's worth like really talking about because when you're in the situation, it can be hard to ask those questions. But the last thing we want to do is leave things, unsaid and send a client into an interview where they are not equipped to talk about the risk and then they're denied. So we always ask the hard questions. Okay. In terms of, again, the nexus, right? This is a reoccurring theme. If your client has a hard time explaining Nexus, or maybe you're having a hard time explaining Nexus through things like the country conditions research, it's super helpful to involve an expert witness. There's a lot I can say about that, but people who have in-country experience or who just have that expertise in the region or the specific country are incredibly helpful at explaining the unique characteristics that our clients have that make them vulnerable. And that's one of the ways we prove nexus. So I think the reason why I'm mentioning this in the affidavit portion is sometimes there's some interplay between the expert and your client. Like the expert might want to speak to your client, or you might want to say like, hey, we have the expert report, can you read it? Because that will better equip them to explain their situation in an interview or even through their affidavit. Okay, so other kind of big issues that we tend to see, there's a lot of unpredictability. So I think, Valerie, this was your case. So Valerie worked a case recently where a whole bunch of stuff from this client came out at the end, like right before he was interviewing for asylum. And then he mentioned new stuff during his interview, like relevant stuff to his asylum case. And we had no idea. That's super common. Like Valerie was very thorough, talked to this gentleman at length about everything that he fled in Indonesia, but yet still more just unfolded as we continued talking to him and during the interview. That just happens. It's very common. Memory issues because of trauma, because of stress, because of sometimes physical abuse or torture. And so I think all of these things kind of require that we be really flexible because they're just normal. Like there is no linear asylum case. It just doesn't exist. Like there is no concrete checklist for an asylum case. We do have checklists, but it's never the same case to case. Like things are always changing and each case is unique. That's one of the reasons why a lot of nonprofits don't take these cases because you can't really like package them up and create like a what's the word? Just like you can't like repurpose like a case you used a case you filed previously. You can't just like go off of that as a template because each case is so different. Okay. Let's see. I think, I think just being fl as flexible as possible is helpful for your client. One of the things that I think about a lot is that most of us in this field, like if you're doing legal work, you tend to be a little anal, right? That it helps to be anal because we have so much to cover, so much work to do. But I think that's very helpful if we restrict that to the case, like our case work and not the client. Like we want to, we don't want to be anal with the client because kind of circling back to that idea of not exasperating your client, it makes everything worse and they might just never show up again if we're too high strung. Okay. So that's the affidavit. I'll pause there. Legal team, do you have comments to add? Does anyone have questions? Okay. Okay, the second big portion of the case is country conditions. So we have a really helpful, it's an 18-minute video on how to complete country conditions. The link is here, like this is a hyperlink. And then here's a link to a sample table of contents. So I won't spend too much time on country conditions research, but one of the things that I do just as like a cheat is if I'm doing an intake for a country I'm not super familiar with, I look at this Freedom House. It's like a scoring mechanism that they use to rank how free countries are. So it gives me at least a sense of like, okay, is this like a really um, bad country in the sense that it's going to be easier to argue your asylum case? Or is it kind of a middle of the road country where it's going to be harder and we might need an expert because it might appear like it's not that dangerous? In other words, like the government could protect the client. So I always like starting there. It's just a helpful little cheat. I think we're just in this really weird situation now with the Trump administration because the countries the nationalities in our country right now that should have the strongest asylum cases now all of a sudden don't because if you're from a country that's on the travel ban list, that's considered a significant negative factor for discretionary cases. So all of a sudden we're in this world where like if you're filing from a country that's not as dangerous, your claim might actually be a little stronger than if you're filing from Haiti, for example, that's on the travel ban list. So just something to be aware of. I think a lot of us think that it's still worth filing from those countries, but it's just a bizarre wrench they've thrown our way. In terms of guidance for when you're completing the research for country conditions, one of my favorite regulations is this, it's quoted here, that the pattern and practice of persecution of similarly situated people. So when you're researching that, you're just looking for people with the same characteristics as your client in the country of origin, right? And documenting what happens to them. And if you have like widespread mistreatment of such folks, then that's really helpful evidence for your client's case. Okay, so I won't go through all of these because again, it's designed to be like a checklist. But I will, so these 3 tips down here I think are very helpful, especially now in like this current environment. You do want to focus on time relevant articles and sources. So like for example, if you are working a Northern Triangle country case, so that's Honduras, Guatemala, El Salvador, As you probably know, our government has made it almost impossible to win one of those cases for a lot of reasons. And one of those reasons is that they say those countries are perfectly safe now, which of course they're not. Well, it's pretty easy to find country conditions research documenting how bad those three countries were in terms of like gang violence, domestic violence, gender-based violence from the period of like, I'd say about 2000 to like 2016-ish. There's a lot of documentation about it. But since then, the documentation has made it seem like those countries have really strengthened like their criminal justice systems so they can provide protection. And that's not always true. Like in those countries, it really varies from region to region, like how effective the police is at responding to crime, right? Or how likely a judge is to issue a protective order when a woman comes and asks for one because her husband's abusing her, right? So I'm saying this because it's tough if you're dealing with a situation like that, where you know the truth is that the country is very dangerous for your client, it can be very hard to find the documentation to support it, which again is another reason, sadly, for an expert, because they can usually provide you with the more accurate picture, especially when it's a regional issue, to strengthen your client's case. And of course, like you want it to be recent enough so that you're arguing in support of the future fear claim. Because if your client fled a while ago, you're always anticipating that the government is going to say it's perfectly safe now for them to return to. So that's why, bearing in mind the time frame is helpful. We've also had some issues with AI, so you should never use AI generated sources like to file with the government, but I would be careful as well, like just don't rely on those summaries from AI, like go to the actual source. Um, because there's a lot of weird stuff that's been happening with that. And the way it works is like we generally file our cases online. So you upload PDFs of the source, whether that's an article or a report, whatever. You're uploading the full like entire source, not just one page that you're citing. And another like strange, I don't know why this is happening, but we're seeing that articles that document the stuff we're trying to document are like disappearing. You'd think that we're all like conspiracy
Hmm.
theorists, but this is actually happening. Like I've had issues with the Center for Gender and Refugee Studies. It's a great resource for especially country conditions research, and I've had issues accessing their materials. I don't know what that's about. I know others on our team have had issues as well, like sources disappearing. So if you find something that's helpful, just save it right away so that you don't lose access to it.
I have a real quick
Yeah,
question.
go ahead.
How far we can use those articles, like year-wise, like 10
I,
years ago, 5 years ago?
I think it really depends on the claim. Like if the persecution happened a while ago, then yeah, use sources from a while ago. But if you're going to do that, then you definitely want something more recent to show that there's still a fear of future persecution. Yeah. So this is really rare, but there is something called humanitarian asylum. So I won't get into too much, but if you prove past persecution on account of a protected ground, it changes the analysis that is forward looking. So if you're curious about that, I can talk to you about it later. But that's like a very narrow exception where there isn't as much of a burden to provide that recent documentation. But generally speaking, you want to have it if you can. Okay, anything else on country conditions research? Okay. All right. Evidence collection. So really broad in terms of like, what does that mean? Helpful to know what it can consist of, though. So like, we can't use videos, unfortunately. Um, Everything has to be documentation. So like I mentioned, we like to file online. I think they only accept like PDFs, JPEGs, it's certain file types, like not Word documents. Um, So everything has to be submitted in that form, but you can get creative. So like say you have a really scary audio recording that the persecutor left your client. Well, just transcribe it. Make it a central part of your case because that would be powerful evidence. And then just say like, hey, I have this recording on my phone. I'll bring it to the interview. So you transcribe it, put a little notation on the transcription, and that's great evidence. So you can get creative even though you're limited to just documentation. Any picture you file needs to be notated with really as much as is helpful for the officer to understand. Like it should be dated if possible and explain who or what's happening or who the persecutor is or why it's relevant to the case. I think one of, again, like kind of a mistake that is made by newer advocates is that there's an assumption that submitting more is better when that's not true really for two main reasons. One, the government's probably not going to read most of your case anyway in this environment because of the backlogs just being so huge. And so that's not necessarily a reason to be like sloppy and not file things, but it's a reason to be intentional and to try to make things concise when you can so it's understandable, like your case is easily understandable. And two, one of the other reason that's not a good thing to do is that if there's anything remotely contradictory in your filing, it can be used to say that your client's not credible. So really, whenever there's a question about that, like is something contradictory? Does it even just look shady? Like sometimes documents from foreign countries just look shady. So if you don't need that, like if it's not a requirement, then a lot of times it's better not to file it. Um, so like for example, we had a case about 2 years ago for an Afghan woman who was in a polygamous marriage. And so our government does not acknowledge any marriage that's polygamous beyond the first one. So, like, say I have three husbands, right? My first husband, like, chronologically, he's real. Like, that's a real marriage according to US law. But my second and third husbands, they're not real. So, we had this client who kind of did not want to disclose that to the government, but I found out that that was the case. Um, and I explained to her, like, we had to be transparent with the government. She didn't want to tell the government about it. So what we ended up doing is we did disclose the marriage, but I did not disclose all of the marriage documents because it wasn't a necessary part of the case. The husband isn't in the United States. We disclosed everything, like all the documentation for the kids that were in the US, but not the husband, because they didn't need to know that. We put his name down on the application, but we didn't put the marriage certificate and everything else that could indicate that it was polygamous, because it wasn't relevant to the case. The government didn't need it. So I think it's really helpful to be thoughtful about that kind of stuff. Because sometimes like you want to withhold evidence. We never want to be dishonest. Like in terms of ethics, we always want to be honest with the tribunal, right? That's the ethical rule. And we want to encourage our clients to answer honestly. But it's also necessary advocacy to withhold things that are going to prejudice your client, like lead to a denial, as long as the government isn't asking directly for it. So this is where I think it's helpful just to have adequate supervision over cases because someone with experience can help you determine like what's helpful and what's harmful. And then in terms of experts, super, super helpful. I think having access to experts is one of the best things you can do. I mentioned the Center for Gender and Refugee Studies. This is a hyperlink to their website. You can do a technical assistance request for your country that your client is from to get all kinds of resources like articles about the conditions, a list of experts, if they're doing pro bono work, if they charge, that kind of thing, their CVs. It's a great resource. And so thinking about like what do you use an expert for? There is the country conditions stuff we talked about, but then there's also the medical and psychological issues that you might want to document. So there's a 1 year filing deadline for asylum, right? You generally need to apply within 1 year of entry or your last most recent entry. But there's an exception for serious mental disability or serious physical disability. So a serious mental disability that's common for our clients is PTSD. So if you can document that and create a nexus between the PTSD and the delay in filing, that's a really strong argument for that bar to asylum. But there might be other reasons why you want to get a psych eval beyond like the 1 year bar issue. Um, and those are generally like memory issues if your client's not real consistent. Um, or like kind of related to that point, if they have the appearance of not seeming credible. So if your client has memory issues, a lot of times you want to file a more sparse affidavit, more generic, like generalized explanations, because you don't want them to contradict themselves in the interview. And it can be helpful to supplement that with a psychological evaluation. And then in terms of like the actual medical evaluations, those are helpful to corroborate scarring and injuries that are a result of persecution. So like a real common example is documentation of FGM, female genital mutilation, or just like any scarring on the body um, that your client either remembers and can tell you about or can't remember, and maybe you can have some new insight from the medical professional who can tell you what was likely inflicted on your client. Super helpful and powerful evidence. Okay, I'll pause there. Thoughts, comments?
For the extraordinary circumstance exceptions,
Mm-hmm.
that vary by circuit.
So it's regulatory. I'll put so it's 8 CFR 208.4. The site is actually in the slide here. Oh, sorry. So the actual exceptions are regulatory. I'm not aware of any circuit precedent interpreting those exceptions. They might exist, I'm just not aware of it. But one thing to note too is that list is not exhaustive. Like the regulations actually say that. Like these are just examples. It's not an exhaustive list. So if you have something that you think is arguable, you might want to go for it and make the argument even though it's not a part of the list.
And children under 18 also
UACs.
have the exception.
So I think that the exception is explicitly unaccompanied alien children, right?
I think.
We can pull it up. If you want to stick around, I'm happy to pull it up after. But because there's a distinction between children and the legal term unaccompanied alien children. But I can look it up after if you're curious. In either case, though, like even if it is UAC, that's kind of an example of where you could make the argument, well, like UACs are protected, this child should be protected, you know? That's like the spirit of the regulation. Yeah. Yeah, because unfortunately, we're going to get into this next week when we talk about briefs, but that has been a heavily litigated issue. Who qualifies for UAC protections and who doesn't, which is really sickening that our government is trying to strip children from those protections, but it's rampant. But yeah, it's a great point because like children, how are children supposed to find lawyers? It's really unreasonable. Okay, any other comments, questions? Okay. So there's synonyms for the legal argument. Brief, memorandum, cover letter. People refer to it using different words, but it's just a legal argument why your client qualifies. So generally, you're really focusing on that definition of a refugee, the elements that I mentioned, like that important slide that we went over. You might also get into bars. You're generally addressing the 1 year bar, regardless of whether it's applicable. But you may or may not, as a matter of strategy, address other bars. So we'll talk about this next week, but there's all of these strategy decisions along the way with asylum cases. Like, you know, do you want to flag something for an adjudicator that's not favorable for your client? Because they might not even think about it, you know? Asylum officers aren't always the sharpest tools in the shed. So, and they have minimal legal training sometimes. So you might not want to present something that could just come back to bite your client. The other side of that coin is, well, but what if this is like front and center for the asylum officer, and if we don't address it, then they're just going to be denied. So there's all kinds of opportunities to like make those strategy calls. So you're doing the definition of a refugee, you're addressing bars, right? And then you're addressing any other legal or procedural issues, like Jennifer just mentioned, like the UAC issue. That would be unaccompanied alien child. That would be a jurisdictional issue because, like, any UAC is supposed to interview with the asylum office, not the courts. Like, the asylum offices are supposed to have initial jurisdiction over all of those cases. And it's really egregious, but there's been a ton of litigation over that that resulted in a nationwide settlement that resulted then after that in a USCIS memo about who qualifies and who doesn't. Anyway, the point is like when you're dealing with issues like that, you want to put that in the brief so that your bases are covered so they don't just like bounce your case to the courts because they think that they don't have jurisdiction. So we'll go over more of that next week and I have some sample briefs for you. Thoughts on the legal argument?
How long is it advisable for this to be?
Sure. So in an affirmative context, I would generally not make it more than 10 pages. I think the shortest one we filed recently was about 2 pages. Yeah, so I would say like ideally like 2 to 7-ish.
Wow. Thank you.
Were you thinking longer?
Shorter.
Okay, yeah. So, and I'll give you examples like I mentioned. So we use a particular like outline for our briefs that it was modeled after the case assessments that asylum officers have to write up when they're deciding the case and sending it up for approval with their asylum office supervisor. So we modeled ours after that. And ours are pretty simple because, like I mentioned, a lot of asylum officers don't have a ton of legal training. So we really try to distill things down. It's just that we're also trying to create a foundation that will be a good one if our case is transferred to court. Because generally, in my experience doing removal defense, judges tend to be way more sophisticated. Under this administration, that's not going to be true. But in the past, it has been true. So your briefs tend to be a lot longer and your arguments are much more fleshed out. So I think that the max right now for the immigration court is 25 pages, double spaced. But like with the asylum office, I would never do that in this environment because I think it'd be counterproductive. They just wouldn't read it. Anything else on legal arguments or briefs? And this is a little bit beyond the scope of this talk tonight, but when you're in the interview representing a client, when they're interviewing for asylum, you also get the chance to do a closing argument. Generally, officers don't like you to go beyond 5 or 10 minutes in that argument. And so for that, you're condensing that legal argument down even more into the highlights. So like nexus, that's something you're always going to address in the closing argument because it's so important. And then you're just kind of highlighting what other important pieces of evidence you have. So you can kind of see the way these cases build, the different working parts like rely on each other. So you're using your brief for the closing argument, and a lot of times your expert report is like probably your most important piece of evidence for a lot of cases. So you're highlighting that in the brief and the closing. So everything kind of builds on itself.
Is the closing argument presented orally or in writing?
So usually you get the chance to do it orally.
Hmm.
That's always been my experience. I have heard of other attorneys being asked not to do it and to just hand it to the officer. So our practice, what we usually do is we go with like an outline of what we're going to say and we offer it to the asylum officer. Like we do say it orally and we keep it quick, but it's easier for the officer if you give them a little handout so then they don't have to take as detailed notes. Because a big part of our advocacy is like we really try to make things as easy as possible for the officer. Like we want it to be simple. We want to be super generous in there, right? And just make it easy for them to just approve the case and like our client and understand what's happening and feel really guilty if they deny it. That's the goal. Okay, so the actual application. So the first like four-ish pages, if you pull up the I-589, you can just Google it and you'll find it. The first four-ish papers are just like demographic information. So for clients who have been to some school and can read and write, they can usually fill that out on their own. But it's surprising how many people make errors when they do that. So it's really important that that be as accurate as possible. So whatever route you have to take to get that to be accurate, do it. The client does get the chance to fix errors in the interview, and that's fine. It's normal to have errors. Like it's not a huge deal. But if there's going to be a lot of errors, that could be a red flag, a credibility issue. So that's why, you want to get all that information. I think there are opportunities for confusion even where you might not anticipate it. So for example, like the client lists out their family, like their mom, dad, their siblings, and then their own nuclear family if they have one, like a spouse and children. The common issue I've heard about, it hasn't happened in my cases, but is the client will think they're only listing their children that are present in the United States. So they'll just not list the other kids, which is a huge issue because if they're approved and they then want to file to join petitions for those other kids to come, if they're not listed on the 589, it's very, very hard to get a follow to join petition approved. So there's just little things like that where clients can make assumptions if you're not there doing it with them, even though it involves a lot of work for us to do that, to do the whole application with them. So, use your judgment in terms of how you do that, the first portion of the 589 that's more straightforward. But then there's the substantive portion of the 589, which is asking the legal questions. And that should generally be done by you, the advocate, and not the client, because we're really best positioned to know what's relevant and how to keep that short and simple and understandable. So you usually just pull from the client's affidavit to fill in those substantive questions. And then so about 3.5 years ago, USCIS wrote out an online system which allows you to file online. It's a horrible system. It works some of the time. I know a lot of you have probably used it. It's very bad, but I think it's better than paper filing for a lot of reasons. Like it's quicker, it's easier to monitor, it's easier to specifically monitor for government mistakes, which are frequent. So even though it's a pain, there are a lot of benefits. So that's why we generally file online.
A question.
Yeah.
When someone files a fee waiver, the instructions say you have to send everything through the mail. Do you know if there is even a fee waiver for asylum?
So for the $100 fee,
And well, it's higher now.
I think the fee for asylum. Are you talking about the work permits or asylum?
No, maybe work permit. You're right.
Yeah, so that first work permit application based on pending asylum, the $550, that you have to pay. There's no
No waiver.
fee waiver for that one. I
Okay.
believe that for subsequent applications based on C8, I think that there's a fee waiver application option for that one.
Mm.
I haven't gotten there yet, but I think it's an option.
Okay, thank you.
Sure. Anything else on the application?
So you said short and sweet. So should you try to just use the box and not add on additional pages where you can add additional pages at the end if your answer doesn't fit?
Are you talking about paper-based or online?
Well, online, I mean, or I guess on the online, I haven't used it. So you're not
Okay.
uploading a PDF that's fillable. You're just doing it online.
Yep. So the reason why I ask the distinction is I think online there's more than enough space with the characters they give you. But in the PDF form, it's less space. I would say in general, though, in either case, try to keep it, try not to add something at the end for two reasons. One, it's like these officers are so incompetent. I hate to be so negative, I'm sorry, but like you'd be surprised at what you like. I'm just hearing horrifying things right now. So like you just want to spoon feed them, right? So if they have to turn another page, like don't make them do it. Just try your best to fit it in there. And it's like the continuity, like it's just it kind of breaks up the story if you have to flip a page and they might forget to do it, right? And two, in terms of their memory, like you want them to remember your case when they're interviewing your client, and it's just easier if it's shorter for them to remember. So yeah, use your judgment, but that would be my recommendation. Keep it short. Okay, anything else about the application? Okay. Okay, the interview. So I know it's a little bit messy when you are doing limited representation, submitting the case. It's really unfortunate that we're in this position where we have to do this because we would like to like submit the case, then be on the hook for the interview. That's what we like to do full scale representation. But there's a couple reasons why we're not doing that. One is the unpredictability. Clients can wait a couple of weeks up to 10 plus years for the interview, and there's no way of knowing which one it's going to be or if it's going to be some sort of like something in the middle. So that unpredictability is really hard. The way we've worked it in the past is we've guaranteed a year of representation at a time. That just keeps it more manageable. But unfortunately, one of the hostile policies that the government has implemented is that they're not allowing remote representation of advocates. So like our legal team, we're spread out across the US and our clients go down to Arlington, Virginia. So it's really costly to go down in person, and the government only generally gives you a week to 3 weeks of notice. That's been my experience, sometimes a little longer. We had a couple interviews where we had more notice this fall, but my most recent interview, I was given 1 week of notice. And the government will not reschedule because of the advocates' unavailability. They just won't do it. So because of all those barriers, we're in a position where now we're doing limited representation because it's just so unworkable. So the way we're going to do it for these clinics that I mentioned is we'll do a high quality filing, explain everything to the client, and we've created a referral list of trusted lawyers down in the Northern Virginia area that can provide representation at the interview. It's likely our clients are going to have to pay for that, which is a bummer, but all of our work is pro bono. So that's how we're trying to achieve a smooth handoff. So the way we do things at Arise, like prepping the client for their interview, we give clients a half-page cheat sheet of the high points we want them to cover for their case. I would highly recommend doing this. I think it works very well. Like no matter how complex or convoluted your client's story is, you can always whittle their case down into half a page, an outline of the most important points. Because if you think about it, like your client's going to tell their story as long as there's no like significant mental health issues or like serious trauma, your client's going to have a lot to talk about that's like, it's fine. It's not a worry, right? You don't need to coach them in every aspect of their testimony. But there are certain things you want them to cover because you need them to hit the elements, right? So that's why we do a half-page cheat sheet of the core things we need them to talk about. This is kind of in contrast to other approaches. Like I've seen a lot of lawyers do like a script of the common questions are probably going to be asked and then the answers the lawyer wants them to give. That's very thorough. Like that can, and every once in a while you might have a client that wants that, but I think it's overwhelming for the vast majority of people. That's why we don't do it. So that's kind of like two, and yeah, go ahead.
It's okay for them to read from the cheat sheet
No, they don't take it. The idea is for practice.
for practice.
Yeah, I'm
Okay,
glad you
thank you.
asked that question. The idea is like for them to memorize it or just be familiar enough with it so they can hit the main points. Yeah, so we give them the cheat sheet. We discuss at length like what to expect because that's a huge part of being trauma responsive is like giving people an idea of what they can anticipate. And then ordinarily we would practice with them, but this clinical model that won't entail practice. And one of the reasons for that is that we want the new lawyer to have the chance to prepare them because some of this stuff is strategic. So we'll give them a half-page cheat sheet of the facts, but we're not going to give them feedback about the interview because we want the new lawyer to be positioned to do that. Because even though it's pretty unlikely we would give like contradictory feedback, it might be like a difference in terms of emphasis. Like I might emphasize one thing, whereas the next lawyer might emphasize something different. And the last thing we want to do, is like give competing feedback to the client. So half-page cheat sheet, explanation of what happens. We'll give them a referral list, and then we will offer to clients, like if they're called for an interview, they find their new lawyer, they can always call us and we can have a meeting with them and the new lawyer just to explain everything so it's a smooth handoff. So that's what it looks like in terms of the clinic. I will pause there. Thoughts? Questions? Okay. Other things to just think about. So credibility is always important in asylum cases. I think it's especially important now. Um, and thankfully, like I think asylum seekers are one of the best groups of people to work with. Like the bravery that's required to leave and then to come here and then go through this process is pretty amazing. So I don't think this is a big issue, other than the issues we talked about, like the memory issues or those defense mechanisms, or like how people aren't afraid when they should be, those kind of things that you can work through. But one thing to be mindful of is like you're always encouraging your client to be honest, right? Maybe not to volunteer certain things that could be seen as like derogatory, but you're also thinking about the appearance of honesty, right? Because, as humans, we sometimes have different perspectives on what looks honest and what doesn't. So I think it's really helpful to be very direct with clients if they're coming off like, if you think they could be shady, right? Or if you think that they look cagey in response to questions, because those can be like defense mechanisms, right? But we want to make sure we're helping them present in a way that's the best for them. So like I'll give you an example. We've represented a number of Afghan folks over the course of the last couple of years, and it's kind of timely now, unfortunately, but a lot of our clients served. They were men in Afghanistan that served alongside of our U.S. Special Forces there during the occupation. And so they did amazing work, like incredibly patriotic. They were trying to democratize their country. And so then they went through the horrible withdrawal. They got here and things were really difficult. So for a couple of those cases, the men that I represented in their affidavits, like as I would type out what they were telling me, they would say like, I deserve this protection. Like, I fought alongside this country. You all owe this to me. And like, I of course agree with that. I think that's very well said, but I would tell them like, I would not say that. You have to be careful with the way you present. Even though like, I appreciate your service. I agree with you. So I think having those direct conversations are really important. For one of those cases, the client did not listen. He went to his interview, he did very well, but then at the end, the officer said, "Is there anything else you want to say to me?" And he said, "You all owe me this." It's like, I sacrificed my life. And then he went on like this tirade, and I was sitting there thinking, oh no. But thank God he was approved. And that officer was actually lovely. At the end of his spiel, she looked at him and she was like, I agree. I really appreciate what you did for us. Thank you. So anyway, that idea of things being unpredictable is super common in this work, but we try our best to like get clients to present well to the extent that that's possible. Not always possible. Okay, and another thing to think about is like, we talk about this a lot at Arise, the concept of good enough. Like, we can approach our work being anal, like with our brief, with our evidence, the filing, the online system, all that. But when we're dealing with humans, we want to try to temper that as much as we can. So like even expert witnesses, a lot of our experts will kind of do us a favor and provide reports for a discounted rate because our clients can't pay high fees. So that means that sometimes it's lower quality, like there's grammatical issues, there's like, sometimes people will just copy and paste like material throughout their report and it doesn't flow well, it's not easy to understand. But to the extent like we can get that work done and edit it ourselves and make sure the expert's okay with it rather than having like a lot of back and forth so things get delayed. I think there just is some room for error in these cases as long as the case is supervised by someone who kind of understands that threshold, like what will be good enough. So I think that's again like just highlighting the need for someone experienced to oversee all the cases because there are times like we've had expert reports that were not nearly as thorough as we wanted, but they were good enough. And for what our client paid and for the timeline we were dealing with, it worked. So that's something we're always sort of assessing. Okay. Other comments about just like general considerations for asylum cases and clients. Okay. Then, so this is part 3. We have part 4 next week. If you're interested in applying to join us, we would love to have as many people as we can accommodate. I sent out a separate email about that. If you did not receive that and you want it, just shoot me an email and I'll get back to you. This is kind of
Question.
it. Yeah, go ahead.
I'm sorry. Even if it's out of like another state,
Yeah. Anyone
because
in the US.
yeah, because I finished my program with Villanova and I've been trying to apply for full accreditation, but I need to work for nonprofit agency. Well, do
You need
pro
like
bono.
experience.
Yes,
Sure. Did you get my email or do you need it?
I need it, please.
I think I put my email in the chat. Can you just shoot me an email and I'll forward it to you?
Thank you. Yes.
Yeah, sure. Yeah, so there's two volunteer positions we're filling. Observers, which is self-explanatory, and then country conditions researchers. And in terms of like launching that program, we'll do an orientation and you'll have the opportunity to really understand like how our cases unfold. This series is designed to be a little bit broader, just to give you sort of a foundation before we get started. Okay.
I had a question.
Yes, go ahead.
So, at any point, would you be covering more on the bars? I'm hearing a lot about all of this, the changes that they're doing to public charge, um, things of that
Sure.
nature.
Yeah, so public charge thankfully does not apply to asylum seekers. It applies to other types of applications, but most of the humanitarian applications are exempt.
Wonderful.
Is that the main bar you're concerned about?
Yeah, because all of these changes that are rolling out, it's hard to keep up with number one,
Absolutely.
what the changes are, and are they changing who it applies to? And it's hard to keep track of what's heads or tails here.
It is, yeah. So like legally, which this administration doesn't care about that much, but legally, yeah, like asylum seekers are exempt from the public charge bar. I think one thing to remember is that asylum's discretionary. And of course, like this administration has made clear they don't want people from third world countries applying, right? So I think we've got to get creative with some of those issues. Um, like we never want to submit documentation that indicates that our clients are lower income, right? Even though all of our clients are, but we're careful on those kind of issues. So the public charge bar doesn't apply like overtly, but we're mindful of this like discriminatory administration, right? That they don't want to approve cases from such folks. So yeah, we're careful with what we submit.
Thank you.
Sure. I'm just looking if there's any other questions. Oh yeah, I'll put my email in again. Anything else we can cover? Any other comments, questions? All right, thank you so much for coming out. And hopefully I'll see you next Monday for our final live session, and then I'll send out the ethics one as soon as we get it recorded. Thanks, everyone. Great to see you all. Have a good night.
Thanks.
Bye.
Bye.